Itulah file guna affidavit file guna na file guna sih boleh kuisi boleh lebih reject kuisi kiri reason berarti
I have to buy my plants for doing the Gauhati. Yes. I have to solve.
May it please your lordship.
Yes, yes.
So item number 17,
Ah.
we have filed an additional affidavit. I want to bring it on record, lordship. It can be called for.
All right.
Yes, oblige.
May it please your lordship.
Hmm.
That's it. I pay. Deeply obliged. Yes, I already listed the matter. I had looked.
All right.
Lordship, I think you mentioned item number 12. Lordship, I believe that this matter may come up after 3 weeks. I need to obtain instructions.
Hmm.
Lordship, so.
All right.
This contempt
After
matter,
contempt matter. Okay.
what was passed in the year 2020.
I think.
But I need
2022.
instructions, so your lordship may be
And
gracious.
as per the last order, the government have to file affidavits.
Hmm.
So your lordship, then it run in 3 weeks then, your lordship.
All right then. 12, no?
Yes, your lordship.
Learned government advocate Nagaland Miss V. Sukri
Yes, your lordship.
has prayed for 3 weeks' time to obtain instructions and submit affidavit. All right. Learned Counsel Mr. What is present on behalf of the petitioner. List the matter after 3 weeks.
May I please, your lordship. Your lordship, I beg to mention hearing item number 37.
37.
Lordship, today I have some difficulties, so let the matter be come up tomorrow, lord.
Tomorrow,
Yes, lordship.
on Monday then?
Your lordship, I have difficulties on Monday.
So tomorrow you want?
Yes, your lordship.
Why not today?
Lordship, I have some personal difficulties, your lordship.
How long will you take tomorrow?
Your lordship, it's a small matter. It won't take time. Then your lordship, let the matter come up after 3 weeks.
3 weeks? 3 weeks will be fine?
Okay, lordship.
Or you want a shorter time?
Lordship, tomorrow won't be possible, no?
Tomorrow.
Yes,
All right then. Item number 30?
37, lordship.
37. How long will you take? Just let me know tomorrow.
It will take 10 minutes, 10 to 15 minutes.
All right then. So we will list it as the first item, okay? Uh,
Much obliged.
Albert, we'll list it as the first item tomorrow. What is the item number?
37, Lordship.
37. Learned counsel for the petitioner with the consent of the other side has prayed for adjournment, list them, prayed for adjournment for 1 day, list the matter on 21st, no? First, 1-3. That's the first matter for hearing.
Much.
Lordship, Lordship, again, I'm there to mention item 21.
Hmm.
Lordship, again, here also, I'm bringing for 3 weeks time, Lordship, to obtain instruction.
All right.
Lordship, yeah.
Learned government advocate Ms. V. Sukri, with the consent of learned counsel Mr. W. Zamir has prayed for adjournment. List the matter after 3 weeks.
Much obliged.
To file affidavit.
Oh,
For
Adjournment.
instruction, Your Lordship, for instruction.
Please conduct petition.
oh,
To file.
adjournment to obtain instructions, Mazhab Bhariba, to obtain instructions and to file affidavit. All right then.
Please, Lordship.
Mm.
I'd like to mention item 14, 15, and 16. These are analogous matters. Can this matter will be adjourned?
No objection.
I take the consent of the petition.
Learned counsel, you are for the petitioner. Learned counsel for the petitioner with the consent of the other side has paid for adjournment. List the matter after 3 weeks.
Let it be on 11 March. Your Lordship.
List the matter on 11-3.
Much obliged.
Much obliged, Your Lordship.
My pleasure, Lordship. Lordship, I'd like to mention item 11
Mm.
on behalf of Hakim Dinsel,
Mm.
petitioner's counsel.
Mm.
Lordship, we have a consensus period. This matter can be listed on 21st of March,
Yes,
21st March
hearing matter,
for hearing,
21st of March.
March.
Learned counsel, Mr.
Week was up.
On behalf of learned counsel, Mr. Akin Risom, with the consent of the other side has prayed for adjournment. List the matter on 25 March.
March obliged.
May I please, my lady,
Oh.
item number 13.
Yes.
Here, the state is preferring appeal, so can we grant 3 weeks time? 13.
State, no?
Yes, yes.
Learned public prosecutor,
No, here,
government advocate,
yes,
learned government advocate, Mr.
K. Angami.
K. Angami,
For
with the
petition.
consent of the learned counsel for the petitioner has prayed for adjournment. List the matter after 3 weeks.
Pleasure.
May I please, Your Lordship?
Yes.
For item number 5, representing respondent number 1 and 2. Your Lordship may kindly grant me 2 weeks to file affidavit in opposition.
Yes,
There's no objection.
learned counsel, Miss
I'm for Limatoshi, I Limatoshi.
I Limatoshi, on behalf of respondent number 1 and 2, has paid for 3 weeks time to file affidavit in opposition.
Yes, Your Lordship.
The Mazat Kubar Bhadivasan, beginning of with the consent of the other side. List the matter after 3 weeks.
Obliged.
Yeah, this is Lordship. Lordship, I'd like to mention item number 31, Lordship. If this matter can come up after next week, come up next week.
Next week,
A week, Lordship.
yes. Any objection? Next week, any objection?
No.
Petitioner, you're for the petitioner.
After petition.
You're the, oh. Learned counsel for the respondent, government advocate.
For state respondents, Lordship.
Learned government advocate Nagaland Miss
S. Chang.
S. Chan, with the consent of the other side has prayed for adjournment. List the matter after 3 weeks,
After a week.
after 1 week, so about 1 week.
Obliged, Lordship.
Please allow me to mention item 32 to 34.
22 to 34,
32 to
all are connected,
32 to 34. Please, my lord,
34 to 32 to 34, okay. Yes, yes, yes.
my lord, on behalf of this friend,
Mm.
for the measure may be listed on 12 March.
Learned counsel, Mr.
Okay, this is our, my lord.
On behalf of learned counsel, Mr. P. Suryan,
Yes, my lord.
with the consent of the other side has prayed for adjournment. List the matter after 3 weeks.
No, on 12th of March.
Oh, on 12th of March. List the matter after on 12th of March.
Please allow me to mention item 26.
Yes.
I for a private respondent.
Hmm.
26.
Yes.
I need to receive the request petition, which is filed by the petition.
Hmm. I didn't get you.
I have yet to receive the request petition,
Hmm.
so I will be allowed to take the request petition.
What petition?
I have had a petition,
Ah.
but because of the default in.
Okay, okay.
For the private restaurant.
Okay, okay. Counsel, sir. For the private respondent, has prayed for, with the consent of the learned counsel for the petitioner, has prayed for adjournment. List the matter after?
There's a application of delay also. So after 1 week,
After what?
in the meantime, I will provide all the.
Yes, yes. Meanwhile, learned counsel for the petitioner to provide copies of the petition and relevant documents to the respondent, private respondent.
Please.
Yes, yes.
Your Lordship, I beg to mention item number 28.
28 years.
I have instructions to appear for the respondent.
Hmm.
So I will find my Palakuma open.
Okay, okay.
It's completed, I have received it. And
Learned counsel, Mr.
PB Paul,
PP Paul is appearing on behalf of the respondents.
1 and 2.
Respond number 1 and 2 and is paid for time to file his wakalatnama. Learned counsel, Mr. Watijami is present on behalf of the petitioner. List the matter after 3 weeks. All right.
Please, Your Lordship, I would like to mention item number 39. Your Lordship, my senior has some personal difficulties today, so if the matter could kindly be fixed on March 18.
Right.
Yes, item number 39.
For the petitioner. Objection.
Learned counsel, Miss
And solo.
N Solo on behalf of learned
Respondent.
counsel, Miss
Mr. Imti Longjun for responding.
Mr. Imti Longjun has, with the consent of the other side, has paid for adjournment. List the matter after 3 weeks.
March 18th, Your Lordship.
List the matter on March 18 March.
Your Lordship, I would also like to mention item number 41.
Yes.
If the matter could kindly be fixed on March 18th as well.
You are for
The petitioner.
the petitioner. Learned counsel for the petitioner with the consent of the other side has paid for adjournment. List the matter on March 18.
Yes, Your Lordship. Your Lordship, there's an interim as well.
Interim order shall remain in force till then.
Your Lordship, I would also like to mention item number 7. Lordship, if 3 weeks could kindly be granted.
This time you are for the respondent, not the petitioner.
For the petitioner, Your Lordship.
Learned counsel for the petitioner, Miss So-and-so, with the consent of the other side has prayed for adjournment. List the matter after 3 weeks.
Much obliged.
Maybe that leadership. I beg to mention item number 6.
Yes.
I bet that this matter may be listed after 3 weeks, my lord. I've taken the consent of the other side.
Learned counsel, Mr.
And no comment.
N. Longkumar, with the consent of the other side. Yes. Anybody is present? Have you taken consent?
Yes, yes.
The matter after 3 weeks.
Okay. By the way, mention item 8 and 9. Next week, Lordship. 8 and 9.
8 and 9.
Lordship.
Learned counsel, Mr.
Correspondent.
And so, with the consent of the other side, has prayed for adjournment. List the matter after 3 weeks.
1 week, Lordship.
List the matter after 1 week. All right.
Lordship, I beg to mention item number 22.
Mm.
Lordship, here, if Lordship may kindly grant me 1 week time to file my affidavit of service.
Affidavit of
Service.
service. Okay. Learned counsel, Mr.
Metofero on behalf of M. Das Gupta.
Metofero on behalf of learned counsel, Mr. M. Das Gupta has paid for 3 weeks time.
1 week.
1 week time to submit his affidavit of service. List them, list accordingly.
Right, Your
For motion, item numbers 1 and 3, 1 to 3.
I'm making mention of the petitioner, the appellant, Z. Kulnu. Lordship, after some time, Your Lordship.
Sometime.
Yes.
1 to 3.
Yes.
All the 3 items,
Yes.
all right. After some time.
For motion, item number 4.
Lordship, this incident material relates to non-consideration for regularization of my service. Lordship, I was appointed as work test sweeper under the executive engineer BWT R&D under Women Division in the year 1991. Lordship, as per the schemes formulated by the through office memorandum issued by the personnel and administrative firms. Those work charged who has completed 30 years or more than that, they are entitled for regulation. Lordship, I have already served in the department for nearly 33 years.
All right.
And still my service has not been regularized. I've approached the respondent authority times, also made a representation, but till date, my service is regularized. Thereby, Lordship, I'm approaching
Yes,
this.
yes, will issue notice, yes, will issue notice.
Lordship,
Have you received notice?
no, Your Lordship, there's a representation that is still pending for the chief engineer. So, Your Lordship, if direction can be given to dispose of the representation first.
Pending in the chief engineer's office?
Yes, Your Lordship. The petitioner had submitted his representation, which is still pending disposal.
Lordship, in similar situated cases, usually it's disposed directing the department since it is already.
Yeah, we can give a direction. I can dispose it.
Yes, Lordship.
Representation.
To consider matter, but as per the office memorandum.
Consensus.
So I can dispose it of. It's up to you because it has to be considered as per the norms
Yes, Lordship.
of the office memorandum.
Yes, Lordship.
So I can give a direction, I'll dispose it of.
Lordship.
All right? So have you annexed the representation?
Yes, Lordship. Page number 25, next year. And Lordship will find the office memorandum. Annexure C, page number 20.
Annexure C is the office memorandum and Annexure E is the representation. All right. Pardon, Mr.
HH.
S.H. Kinmi, learned counsel for the petitioner, Mrs. Wanpen Konyak, and Miss
AIME.
AIME, learned
behalf
government advocate, now Nagaland. The petitioner has filed this application under section under Article 226 of the Constitution of India for issuance of a writ of mandamus or certiorari or any other appropriate writ or direction the respondents to regularize the service of the petitioner from the day of completion of 30 years of service with effect from 2021 with all consequential benefits. So it is further prayed that the state respondent is to apply the same yardstick as similarly situated person and regularize her service. Heard Miss so-and-so for the respondent number 1 to 6.
Yes, your lordship.
All the
1 to 6.
respondents, 1 to 6, who has submitted that the representation marked as Annexure C or no, E, Annexure E of the petition is yet to be considered, and the the representation would be considered by the respondents. All right. As per the applicable norms, all right? Full stop. The petitioner's case is that the petitioner was appointed as work charge sweeper by order bearing memo number capital MD stroke WC -4 608-09 within bracket capital A bracket close with effect from 18/6/1991. Full stop. It is further submitted that the petitioner has served the department for 32 years and is still in service, full stop, as per office memorandum bearing number capital AR-3 stroke capital GEN-201 stroke 2009 dated 17/3/2015, comma, clause 1 within bracket small a bracket close, all existing work charge and casual employees of various departments who have completed 30 years or more in continuous service as on 1/1/2015, comma, they are to be regularized, full stop. However, in spite of the above mentioned office memorandum dated 17/3/2015, the services of the petitioner has not been regularized. So it is submitted that it is submitted at the bar that the representation of the petitioner is still under consideration, and considering the submissions at the bar with circumspection, the department of the department hyphen respondent number 3 is directed to consider the representation of the petitioner
Your
as
lordship,
per OM.
Respondent number 5.
Respondent number
Not
5, okay, is to consider the representation of the petitioner as per the OM number AR-3 stroke GEN-201 stroke 2009 dated 17/3/2015. Anything to be included in your prayer? Anything to be included? This will serve the purpose.
Yes,
In terms of the above observations, this petition is disposed of.
I know.
From the supplementary cost list for motion, item number 42.
May I please, your lordship?
Yes.
This is 438 application, lordship. Your lordship, FIR will find page number 10, lordship. Yes, may I read, lordship? With due respect, I am complainant back to state that Mr. Tony Rana, son of so and so and so, serving Assam Rifle posted at so and so, district so in Manipur, had
counsel his for my marriage and convinced me to marry him. Thereby on 17/10/23, we went to Tinsukia Court, Assam, and filed a marriage petition to register our marriage, and he dropped me to Dimapur and returned to Tinsukia, Assam. Mention to be made herein that the fact of the former marriage came to light only after we had filed a marriage petition and after he disappeared from the Dimapur. That the accused has induced me to transfer rupees 2,40,000 only for one business venture, hereby I had transferred the said amount on date so and so to the HDFC Bank account. That on 6/1/24 he came to Dimapur and we settled in single Angbi sector C, Dimapur, Nagaland at rented house as a husband and wife. On dated 60/1/24, I had purchased a one Royal Enfield Enfield bearing registration number so and so and so and so and so and so color. On 21/24, he had taken said Royal Enfield on the pretext of attending his unit at his posting place of Maram. However, after 22/1/24, I lost contact with him as he has put my phone number in blacklist and is absconding till date. That accused with the fraudulent intention had cheated me by filing the marriage petition in the court, dishonestly induced me to deliver the amount of 2,40,000, taken my vehicle, Royal Enfield, dishonestly misappropriated it and absconding till the date. The accused with malified intention and clandestine motive, he had conceived me to marry him, deceived me by causing both mental and physical tormenting with amount to rape, cheating, and this is the allegation of the
So you're booked under which
first
sections?
thereafter, Lordship,
Yes, you are booked under which sections? The sections are not mentioned.
section is not added, that is why Lordship I proceed. After this, receiving this information, police of the Dimapur, Women Police Station of Dimapur issued 41A notice. 241, first 41A notice and
So you are
27
actually you are asking for interim bail.
interim, Lordship.
All right.
We will appear and cooperate the investigation.
Let us ask the PP. Yes.
Yes.
This may be issued.
Mm.
Even the complainant is made a party, so I think she should be heard.
No, no.
As per notification.
Complaint need not be heard, I think so. But I think we'll call for the CD without interim.
Lordship, thing is, equal, I have to direct it to appear on 4th of March, Lordship. This is the difficulty. I have appeared, I have apprehension, then I may be arrested. Because 41 or 41's a subsection 3 discusses upon the inquiry officer, Lordship. So for concern to the arrest, I would like
So
to place.
why this sections have not been added? 41A notice has been issued. So I don't know why the sections have not been added. Most probably it will be below 7 years. Otherwise, what is the point of issuing notice?
How much content of the FIR?
Mm.
Content of the there specifically is it amount on rare. It is 376. Cheating also there. I have apprehension.
Cheating is
that-
there, no doubt about it. But
I have apprehension
this-
that this section may be it and I may be taken the custody. But there is the apprehension.
As per the record available on in the applications, I think FIR is not yet registered. It's registered only as GTE.
Only GTNT registered and
But
thereafter.
41A notice has been issued.
Course.
Yes, sir. Notice will page number 15, Lordship.
Mm.
This is second notice, Lordship. If Lordship permit me, I would like to read out.
Yes.
Yes, Lordship. Page number 15, got it, Lordship. Page number 15, that from the second paragraph, I would like to it is to inform you that a written FIR was received from the so and so and so on dated 17/10/2020, both you went to Tinsukia Court as Assam Rifle to remain to register a marriage. That the former marriage came to light only after the filing this petition, and you disappeared from the Dimapur Nagarin. That you have induced the complainant to transfer of amount of rupees so and so for only for the business venture, and said amount was transferred on so an HDFC bank dated so on dated on 6/1/2, you came to the Dimapur board, settled at single Agwin Sector C, Dimapur in the rented house as husband and wife in one. That on 10/21/24, you have taken away the Royal Enfield on the pretext to attending your unit at your posting place, madam. However, she lost contact with you by putting her number in the blacklist, and he went absconding till that the fraudulent intention.
So you have annexed this,
Yes, it's so far concerned to the city lordship.
SBI account,
Yes, so far concerned to the, yes, I.
but this is HDFC account. 2 lakhs have been withdrawn from HDFC account, not.
Yes, I'm coming to that point, lordship. Your lordship, and this HDFC, this is my account, lordship. Admittedly, we have a business venture at Dimapur, lordship. That is why I have given her to 8 lakhs of rupees on dated 28 December, lordship. Kindly come to the page number 17 on below from 4. This is December. Got it, lordship? 28. Transfer to the account number so and so, account number 202017489806 for 8 lakhs, lordship. Transfer to. Now, lordship, I would like to draw the attention of your lordship. This is my SBI statement. Thereafter, lordship, I have come to the page number 20. First, page number 19, lordship. Page number 19 is my bank statement, lordship. My bank passbook copy. And second, lordship, page number 20. This is original copy of the lordship bank update passbook. This is type copy, lordship. So there's lordship, kindly come to the second line. Second line, 28/12.
Yes,
2000 transfer to the so and so account number. This is account number similar to the earlier.
On 28/12, but
This is
your allegation is that on 3/1/24.
Yes.
3/1/24. You have taken away rupees 2 lakhs, but on 28/12 earlier, you have given her.
Earlier, we have given her.
So without the sections incorporated in the FIR.
Yes, lordship, but as per the section 41, lordship, the discretion upon the, I have the apprehension to arrest, lordship, because police already issued the 41 notice. Lordship, come to the 41 note. 41 is here. Kindly please provide here, please. Yes, lordship. May I read the section, lordship? This is 41.
Just a moment, just a moment.
My book is just, you mean,
I'll get it.
43.
Yes.
Section 41. The police officer shall, in case where the arrest of a person is not required under the provision of the subsection, section 41, issue a notice directing a person against whom a reasonable complaint has been made or credible information has been received or a reasonable suspicion exists that he has committed a cognizable offense to appear before him or at such other place as may be specified in the notice. Second, lordship, where such notice is issued, any person shall be the duty of that person to comply with the term and condition of the notice. Third, this is very important. That is where such person complies and continues to comply with the notice, he shall not arrest in respect of the offense referred to the notice unless, lordship, unless for reason to be recorded, the police officer is of the opinion that he ought to be arrested. This is my appearance. Already, discussion is upon the inquiry officer.
All right, what do you have to say? Please, pressing for interim bail.
First notice, he did not appear.
Hmm.
Notice has already been served.
Because he's apprehending arrest, that is why he did not appear. So he's pressing for interim bail that amount of rupees 2,40,000 has been taken by him, but earlier he has given her rupees 8 lakhs according to the bank account.
Yes, but
That person,
yes, the issue is, that part is lighter, but the issue is now, marriage.
Yes, marriage.
Those things are serious. So,
That will be marrying for marrying with the giving the impression that he is not married.
yes.
So he was
Even indication,
indulging in polygamy basically.
yes, indication of rape is shown in the FIR. So,
They,
it's not-
so far
they got married. He has cheated her, no doubt about it. He has cheated her.
but consenting party. They got married, they are living as a husband and wife. This is.
But he was earlier married, but he had concealed it.
During the good days, they are living as a husband and wife. So rape is not.
But then husband should not switch off phone, put her wife's phone number on the blacklist. Something's not right.
Moreover, Lordship, if section is not added or case is not registered, that your Lordship can apply the discretion of the 438.
Yeah,
as
can,
per- yes,
can, that we
as
have
per
done
our
judgment.
petition, as per our constitution with the Gurbakh Singh cases, Lordship. I have brought this as well, if your Lordship want to see.
Gurbakh Singh CBI.
Yes, Gurbakh Singh CBI cases.
No, it is included in that entails case also.
Yes. So if I have reasonable apprehension, then court can. I will.
I think
appear,
interim
Lordship.
order can be granted, I think.
Property investigation.
I think interim bail can be granted, I think. Under objection.
Police station, if you, I'm
Under
cooperating.
objection. I think can be granted. To secure his attendance, then we can, he has to furnish surety, local surety,
Local, sir.
local surety.
Yes.
So amount will be 50,000 then? 50,000? Oh, no, you have objection.
I have objection.
Mm.
This. Of course, the lordship has your discretion, but as far as a on the prosecution side, I think I have to object.
My apprehension is there is reasonable apprehension. I will appear, I will continue this, I will cooperate the investigation, I will appear before the IU, Lordship. I will appear before the IU. Otherwise, is
The informant is Mingma Dolma, M Dolma.
M. Lordship. I will appear before the IU with any condition. Any condition, I will cooperate the investigation. I am not saying I will have to submit all the documents also. This is the only allegations made that phone switch off.
Heard Mr.
R. Burwal.
R. Burwa, learned counsel for the petitioner. Tony Rana. The petitioner has filed his application under section 438 CRPC with prayer for pre-arrest bail as he is apprehending arrest in so and so PS case under so and so sections. Heard Mr. You
Your
keep
name.
forgetting your name.
K. Angami.
K. Angami, learned public prosecutor in Nagaland, on behalf of respondent number 1. I have considered the submissions at the bar with circumspection. It is submitted by, on behalf of the petitioner, that that a false allegation of marriage has been leveled against the petitioner by the informant hyphen respondent number 2. The informant lodged an FIR containing alleging inter alia that on 17/10/2023 marriage was registered. That marriage was registered, no, that the petitioner in the and the informant went to Tinsukia court for registration of marriage. The informant later learned that the petitioner was already married. The petitioner also induced the informant to transfer rupees 2,40,000 for one business venture, and which was transferred by the informant on 3/1/2024 to the HDFC bank account of the petitioner. Full stop. The petitioner and the victim have been residing as husband and wife at Sector C, Dimapur, Nagaland. Full stop. On 16/1/2024, the informant purchased one Royal Enfield motorcycle but on 21/B/2024, the petitioner had taken the motorcycle and had disappeared. Full stop. The petitioner has blocked the informant's phone number, and he has thus cheated the informant. Now the informant cannot contact the petitioner. The learned additional PP has raised serious objection, stating that notice has to be issued to the informant. Full stop. Case has not yet been registered. A GD entry has been registered against the FIR. There appears to be no apprehension of arrest. Full stop. Notices were indeed issued to the petitioner, and the petitioner has not appeared before the IO. Next para. Per contra, the learned counsel for the petitioner has drawn the attention of this court to the bank statement of the petitioner in his SBI account number 0307959720603, and has submitted that the petitioner has transferred an amount of rupees 8 lakhs to the informant on 28 December 2023, which is clearly resembled in the bank statement marked as Annexure B of the petition. The informant's account number, the bank statement of the informant's SBI account number. This is SBI.
No, this is not SBI account number, this is HDFC account number.
HDFC account number.
20.
Where is it? Account number?
Yes. Page number 20, Lordship. There number 4. 20174 890641 of Migma Dole.
Likhila. Clear, the statement clearly reflects that the informant had received an amount of rupees 8 lakhs from the petitioner on 28/12/2023. It is submitted that after depositing rupees 8 lakhs in favor of the petitioner, it is not believable that the petitioner will disappear with rupees 2,40,000 belonging to the informant, and also with the motorcycle belonging to the informant, whose the petitioner is willing to appear before the IO and cooperate with the investigation. It is submitted that the petitioner and the informant had a friendly relationship, and they also had a business the business partnership.
Yes.
Business partnership
At Dimapur.
at Dimapur. I have considered the submissions at the bar, and I have also scrutinized the annexure, ENF, no? Annexure,
Yes, Lord.
ENF of the petition, full stop, and there appears to be a DENF of the petition. There appears to be sufficient grounds to grant interim bail to the petitioner. In the event of his arrest, in the interim and in the event of his arrest, the petitioner shall be enlarged on bail of rupees 50,000 with 2 local sureties, huh? All right, 2 local sureties of like amount to the satisfaction of the arresting authority, under the condition that the petitioner will appear before the IO within 10 days and cooperate with the investigation. The petitioner shall refrain from such activities with which he is alleged. Number 3, the petitioner shall not exercise threats to the witnesses and tamper with the evidence. The petitioner shall appear before the IO after every 15 days till completion of investigation. On breach of any bail condition, bail order shall stand cancelled. Call for the CD, list the matter on. Meanwhile, call for the CD, list the matter on.
Interim is there, Lord.
So,
Last part of the March.
last part, yeah.
File 100 will.
2 weeks.
We'll give a date.
Yes.
Yes.
15 March or later,
Later, Lord.
19 March.
Lord, the last part of the March is.
Okay,
19 is fine.
19, all right, 19 March. Also issue notice to the respondent number 2.
Yes, Lordship, but not required, I think.
Not required actually.
Not required, because only the postal cases is required.
Required.
As per our.
Meanwhile, to be on the safer side, issue notice. You can
Yes,
take
yes.
this back.
Deep locations. Deep locations.
Oh, motion, item numbers 43 and 44.
Lordship, this instant IA is for impeding the complainant as handling number 2 on the civil review petition.
2 of 224.
Yes, Lordship, 2 of 2024.
Complainant as respondent number 2.
Yes,
All right.
Your Lordship, I may be allowed to file an amended petition.
Yes, yes.
And-
Yes, I think so. This is a criminal case.
Lordship, yes.
Criminal case.
Lordship, if there is an interim prayer, so if it can be heard today.
Leading counsel has a MS Mary. She's handling the case, you know, she has some hearing going on in court 1. So if it may be posted to another next week.
Lordship,
Next week,
Lordship,
their main petition.
Lordship, I'll be filing an amended petition.
Yes, yes.
So that time the interim prayer can be heard.
This IA 7 of 2024, what is this for?
This is for impeding the complainant, but the interim prayer is in the main petition.
So today you'll be able to file an amended petition.
Lordship,
File
I-
it next week,
I'll
file it
file
next
it.
week.
Yes,
Okay,
Lordship.
next. Had Miss so and so learned counsel for the, I लिखी हाँ, learned counsel for the applicant. Mrs. L. Angla alias Limangla, alias Limenla, alias Limangla. The applicant has heard Mr. N. Angami, no?
K. Angami.
K. Angami learned additional PP for the state of additional PP Nagaland. This application is filed to implead and array the complainant What's the name of the complainant? Sri Kapming Thang as respondent number 2 in the criminal division petition number criminal revision petition number 2 of 2024. The prayer is allowed and the petitioner stroke applicant to file an amended cost item. List, eto duitate likhi diba. List criminal revision petition and 2 of 2024 and IA 7 of 2024 after 1 week. IA is disposed of.
For admission item number 10.
IA is disposed of.
May it please your lordship,
Yes,
but opposite is central government council.
okay.
Your lordship, this is a quashing petition on the 482.
This is for admission or motion.
It is for admission.
Admission, the opposite party has to be here.
Opposite party,
Party is the private respondent.
He has to be here.
That's a formal party. So in the absence.
State is a formal party, yes.
Yeah.
Affidavit reflect file to the objection on affidavit. So respondent number 2 is being represented. Today he is not represented.
Yes.
Private respondent. Yes, private respondent is respondent number 2.
Yes.
Today he is. So we'll fix it another date.
Oh.
We'll fix it on another date. Today he is not represented.
yes, your lordship, otherwise.
What is the
meeting
point?
is complete, matter may be listed for hearing, your lordship.
No. It is fixed for admission. We have to hear before admitting it.
Actually, it is long pending matter. also.
I understand, but he is not being represented today.
Yes, your lordship.
I can pass an order that if he is absent on the next date, the matter will be disposed of on merits then.
My lord.
Huh? I can pass such an order,
Yes, yes.
but I cannot fix it for hearing. Heard learned counsel Mr. P.B. Paul for the petitioner and learned government learned PP.
PP, yes.
PP,
K. Angami.
Mr. K. Angami for the respondent number 1.
Yes.
The respondent number 2 is not represented today. List this matter after 2 weeks. In absence of any other of the parties, the matter may be disposed of on merits.
If he's did.
Okay, this matter on
18 months. 18 months is,
yes, 18 March,
18,
20,
19,
19 March.
18 months.
18.
I'm having other methods.
Yes. All right, 18 March.
Much of it.
For admission item number 17.
This is a contempt matter which has now taken some very serious turns. If your lordship will kindly see the last order. If your lordship will kindly see the last order passed by this honorable court. I just want to place that to indicate as to what proceedings should take place today and what I'm trying to submit with your lordship. Because last chance was already given. So I'm just placing the last order of this honorable court, 23/1/2024 order.
Yes, please read.
Yes, Lordship. The last paragraph I'm taking, also the last paragraph. It is made clear, what is got that, the last paragraph. It is made clear that no further opportunity shall be given to the respondent contemners for resolving the issue between the Ministry of Road Transport and Housing Government of India, as well as the Government of Nagaland Works and Housing Department. If on the next date, the issue is not resolved,
Yes.
issue is not resolved, this court will be constrained to pass necessary orders to the respondent contemners to disburse the compensation sanctioned by the Ministry of Road Transport and Highways to the affected landowners. So today, we are in a position when that last opportunity that was given by this honorable court has also expired, and the position remains the same. Therefore, I would like to submit to Lordship that I would like to place this matter so that these contemners, effective orders can be passed against them, because the last opportunity has gone. So I just want to place the matter. This is a serious issue where compensation amounting to 60 crores have been granted by this honorable court way back 1 year ago. And this money, compensation money, belongs to thousands of villagers who have been deprived when road constructions took place. Their properties were damaged. Now that money.
Just a moment, let us find out what is their status. Yes.
Please, Your Lordship.
Status is the same. They're not-
On the last occasion, on
Because
23rd,
you see, what is the point of proceeding with a contempt? Let the people get the money. Yes.
Exactly, but they're not paying him. So I'll just place the facts.
I wish to place this before the honorable court. On last occasion, on 23rd January 2024, the state order was passed. Thereafter, there had been 4 communications. Prior to that also, if I may be allowed to refer, the letter dated 23rd November 2023, written by the Commissioner Secretary to the Government of Nagaland, Works and Housing Department, to the Secretary, Ministry of Road Transport and Highways, praying for waiving the recovery of money from the agency charges. That is number 1. If I may be allowed to read the entirety, Your Lordship.
These issues have already been dealt with by this honorable.
No.
Therefore, the statement in that order, if the issues are not resolved, the last order, issues are not
If I may
resolved,
be allowed to read, Your Lordship.
this has already been taken care of. The judgment, if you also with the last order, it says, whatever you want to do, you do it. But if it is not resolved till the next day, then we will have to pass, we will be constrained to pass orders for disbursement of money. Now he's again reopening the issues which were already placed before this court, and the court have observed that you do whatever you want to do. But beyond this day, last opportunity. Now he's again, these are all dilatory tactics trying to delay the payment. So therefore, I would like to place the actual facts. I will place the actual facts. Why they are delaying everything. So let
Your
me
Lordship,
say, but
I may be allowed to highlight how
Let
these
him
things has
highlight,
come
then
about.
I'll come back to you.
all right.
Your Lordship, nowhere in the country, a central project is to be converted into state project. Once the sanction is accorded by the Ministry of Road Transport and Highways, how can it be possible that the entire sanction order accorded for damage compensation will be recovered from the state agency charges? So this is our grievances.
May I?
Nowhere in the judgment and order, which was passed on 30th January 2023, has any reflections or any utterances that this amount will be recovered from the state agency charges.
If I place the facts, the lordship will be able to appreciate
So-
what the submissions are. It will just take me 10 minutes to place the facts. Everything is clear. And in fact.
And the main respondent here is the secretary. If I may be allowed to refer the contempt petition, that is respondent contemptor number 1 is Anurag Jain, IAS, Secretary to the Government of India, Ministry of Road Transport and Highways, Transport Bhavan, 1 Parliament Street, New Delhi. He is still silent. We are only respondent number 2. We are mere state agent. We meant the responsibility of state agent. and we are aggrieved by the sanction order. If I may be allowed to place this before your lordship.
It is already on record as the second.
If I may be allowed to read, your lordship.
Yes, yes, please. Yes,
May I read, your lordship?
yes.
Number such and such, Government of India, Ministry of Road Transport and Highways, any zone. Dated 27 October 2023. To Commissioner Secretary to the Government of Nagaland, Department of Works and Housing, Government of Nagaland. Subject to laning of Longland Changtunga Road, Mont Tamlu Merangkung Road, Pek Procedural Road, and Chakabama Zanapoto Road, totaling 329 kilometers inland in Nagaland under SARTPNE in the state of Nagaland, sanction of award based on the order of Honorable Gauhati High Court, Kohima bench regarding damage compensation. Job number such and such, reference letter such and such. Sir, I'm directed to refer to sanction letter number such and such, dated 9/12/2010, and to convey the administrative approval, technical approval, and financial sanction of the President of India for the payment of award based on the order of Honorable Gauhati High Court, Kohima bench, dated 30th January 2023, regarding damage compensation amount to rupees 60 crore 94 lakhs 36,685. Based on the calculation of TC pack for work mentioned in the subject above, subject to the condition that the amount shall be recovered from agency charges of the state PWD of Nagaland. Nothing was whispered in the judgment and order dated 30th January 2023 regarding the payment of damage compensation, your lordships. And state is a mere agency of the MORTH. The Government of India is the employer. We are the employee. We mean the responsibility of the agent. So how can this money be recovered from the state agency charges? That is our prayer, lordship. That is our grievances, lordship. So accordingly, if I may be allowed to refer the last letter even written by the Chief Minister of Nagaland. Where is it? First letter written by the Commissioner Secretary of the concerned Department of Works and Housing on 23rd November 2023. Second letter was written by the Chief Secretary of Nagaland, dated 12 May 2023. Third letter written by the Deputy Chief Minister and Minister National Highway by his letter dated 12 January 2024. And most importantly, the letter dated 17 February 2024, PO letter written by the Honorable Chief Minister of Nagaland, expressing the same view and the concern about the recovery of the allocation of fund from the state agency charges, your lordships. Otherwise, we are ready to release the money if a direction and necessary information is replied by the ministry. Your lordship.
I have something to on behalf of respondent number 1 and 1 and 2. So
Yes.
I will be given some time to file my affidavit.
Not required. They have already complied. I have got
Thank you.
nothing against respondent number 1 and respondent number 3. They have already complied. They may be struck off also in this contempt proceeding.
Yes,
This
lordship.
contempt only now lies against respondent number 2. If I may be allowed to place the fact.
Yes,
also,
yes, yes.
Because it's a very serious issue now.
Mm.
I will place the office notice also. I filed additional affidavit. I will place the office notice for Deputy CM also, which we have applied under RTI. Let me just place the facts also.
Yes, yes.
How they are delaying this case.
Otherwise, lordship, respondent number 1 and 3, we are not the necessary party in this contempt.
Today is about the necessary party because the checks have already been issued. The checks have already come and reached the Deputy Commissioner Peck. Now they are not releasing because of one statement in that sanction order regarding recovery, which again a division bench of this Honorable High Court categorically have stated it cannot act as an impediment for payment of the money. Also, I have annexed it in my additional affidavit. My brother has appeared in that case, objected, and categorically the Honorable Court have passed, division bench have passed an order saying it will not be an impediment. I'll just take your lawsuit to that, just for a moment. But I'll place the facts.
Lordship, on the submission of the counsel for the petitioner, since 1 and 3 are not necessary, my name will be deleted.
No, your
because it's a
lordship, number one is the
petition.
Union of India, necessary part.
Because we have already deposited the amount.
The amount has already been deposited.
Yes.
But
We have already given the amount.
your
They are
lordship,
not releasing.
nothing was mentioned about the recovery from the state agency charges in the
The
judgment.
union bench, I just played.
Passed
the
on
fact.
30th January.
That is a different point of view, Lordship. But as far as the amount is concerned, we have already deposited.
Yes.
Otherwise,
We are grateful
If-
to the union of India. They have deposited.
But in
they
the-
agree, they can file,
But in the contempt
This
petition,
is a hearing or orders of admission.
It is in admission,
admission hearing.
but the lawsuit has seen the last order. The last order says the last opportunity is gone. So my urgency, the reason why I'm placing this with urgently. The urgency is the checks have been issued. Now, lordship knows under the RBI guidelines, a check has got a validity of only 3 months. Union of India have released the checks. Checks are lying with the deputy commissioner's bank, and he is not depositing the checks for transfer of the money, for waiting higher authorities approval. In the meantime, already 2 months is gone. Only 1 month is now left. After that, the checks will become stale. Thereafter, again, elections are coming in Union of India. That checks will never be revalidated. And this entire case will suffer. The entire judgment will suffer. Will your lordship allow this judicial order to suffer like this? The sanctity of the judicial order has to be upheld. Therefore, let me place this case.
Okay.
I'll just show that these are all dilatory tactics. This writing of letters here and there, they're all dilatory delaying tactics.
no, your lordship, no.
No, that's what I'm trying to place now.
In the contempt petition,
Let me now place.
number 19 of 2023, Anurag Jain, IS, he is the respondent number 1.
Yes.
We are the respondent number 2, your lordship.
Yes.
And
he is
the
not.
money is supposed to be deposited in the state exchequer, but it has gone directly to the deputy commissioner. We are in the dark.
So what now the deputy commissioner has to do?
Without the knowledge of the state respondent, how can you release the money?
I'll just place the facts.
Who will recover the entire fund allocated for damage compensation? Will it be by the deputy commissioner?
So that, I'll start.
So the money, the check has been deposited to the deputy commissioner.
Yes, your
The check
lordship,
has
that's
been-
the problem.
The check has been issued. Yes, it is disbursing authority, yes. The judgment says the deputy commissioner is disbursing authority. So therefore, the checks have reached the deputy commissioner's official account. The check is issued.
So why you are not releasing them? I do not understand.
That is what I'm saying.
If you are a
That
disbursing.
Our grievance is
act of
unless and until a justification is given by the ministry regarding our grievances, our queries, how and why recovery should be made from the state agency charges. That is our
So this
grievance.
is, if I may place very simply,
Because this will amount the state project. Nowhere in the country, a central project will be converted into a state project regarding payment of fund.
this is the contempt jurisdiction. He cannot argue on merits. Judgment is already passed 1 year back.
But nothing is
So let me-
mentioned,
let me
nothing is
place-
whispered in the
we have to
judgment
be
and order
For 10 minutes.
about the
let me just
recovery
place-
of the.
Let me, because
agency.
I have a categorical player at the end. And then last, let me just place the facts.
So there's a technical snag, I think.
Your
Whatever
lordship may
he's
be
saying,
pleased to pass,
Understanding is wrong. Their understanding is wrong. That's
your
it.
lordship may be pleased to pass an order
Their understanding is
to
wrong. The order has already been passed by division bench subsequently. I'm just
reply by the respondent number
Your
1.
lordship will kindly come to page 13 of the contempt petition. Let me just place the fact for lordship's kind appreciation.
Mm,
Page 13.
mm,
This is the judgment.
yes.
This is PIL number 9 of 2019.
Mm.
Lordship will note this because it has been recorded in other judgments also. PIL number 9 of 2019. Now, this case at page 15, Lordship will see the order date.
Mm.
Page 15, Lordship will see the order date. This is 30/1/2023 at the bottom.
Mm, yes,
So this was a judgment passed almost 1 year back,
1 year back.
more than 1 year back. Now, this case, I'll just give a background. This case was filed because a road construction took place in a particular district called Peg of Nagaland. Now, while constructing the road, there were some damages caused to thousands of people's houses. These are hilly terrains. So this land, all this art and all these things and rocks have fallen, and a lot of houses were damaged. Houses and farmlands were damaged. So this particular amount was quantified. The State Department, Union of India, they all went to the site. They did site verification and the amount was quantified. The entire amount was quantified as 120 crores for the entire district. Now this PIL petitioner came for a particular amount, a particular area, some villages, amounting to around 60 crores. Now we told this court that since the amount has already been approved, because they have already done the assessment, but they are not paying this money. So this money has to be paid because these are due money. We are entitled to this money. This honorable court finally at page 21, the operating portion.
Yes.
The last paragraph. The word starts with the word, it starts with the word admittedly.
Yes.
Admittedly, the damage caused to the land and properties have already been assessed by conducting a joint survey, and even the quantum of compensation amount to be paid has also been determined under the leadership and supervision of the Deputy Commissioner concerned. As such, the state government shall make the first move by submitting a proposal along with the assessment made to the central government, the ministry concerned, and on receipt of the same, the latter shall initiate the process for allocation of fund and release the same to the government, state government, who shall then disburse the same through the Deputy Commissioner of the district concerned to the genuine landowners whose lands, properties, standing crops, etc. have been damaged or destroyed during the construction of the road. The whole exercise was directly completed within 6 months.
Yes.
So the order was, since it is admitted, you have to now make a payment. So how will you make the payment? The state government will send the sum to the central government. Central government will release the money and the Deputy Commissioner will thereafter disburse them. And this has to be done within 6 months. So this was the judgment. Now, if your lawsuit will kindly come to the additional affidavit filed by us on 16/11/2023. There is an additional affidavit of 16/11/2023. A small affidavit of around 5-6 pages.
Yeah.
Yes. Now this was filed.
No. This is 24 November.
That's it.
24 November 23.
Yes,
Additional
24, yes, 9 till 16.
Yeah, it was filed on 16, but
Yeah.
registered on
Yes,
24.
yes, that's why my
Alright.
copy 16 is written. Now, if
Yes.
your lordship, now in this additional affidavit, if your lordship will come to page 4.
Page 4, okay.
Page 4. This is the sanction order. Pursuant to the Honorable High Court's judgment, Division Bench judgment, the Union of India on 27 October 2023, that is also beyond 6 months. But then we are grateful that they have at least done this after 6 months.
Sanction order.
27 October 2023,
Yes.
have sanctioned the money. That's 60 crores. So lordship will just see the subject, two laning road of such and such road, sanction of award based on the order of the Honorable High Court, Gauhati, High Court, Kohima bench regarding damage compensation. Now I'll just place the first paragraph, which is relevant because the entire argument of the respondent is on the first paragraph. I am directed to refer to sanction letter assences and to convey the administrative approval, technical approval, financial sanction of the President of India for the payment of award based on the order of the Honorable Gauhati High Court Kohima bench dated 30/1/2023 regarding damage compensation amount of 60.94 crores based on the calculation of DC PEG for the work mentioned in the subject above, subject to the condition that the amount shall be recovered from the agency charges of the state PWD of Nagaland. Now, Lordship has seen there are two parts in this sanction order.
Yes.
The first part is the money is sanctioned as per the Honorable High Court's order. There is
Yes.
also a particular condition there on bold, in bold, which says later on we will recover this money from the state's agency charges. They are agreed with this particular portion of the sanction order. I must say this sanction order is not challenged anywhere by any court or any forum. The sanction order today is there without there being any challenge to it.
All right.
Now, this sanction order has two parts, procedures in that. One is the release of the money. Second is later on a recovery. Now, my argument always has been recovery is a different subject altogether.
Yes, yes.
Recovery will be subject to you and the Union of India.
Yes, yes.
There is a dispute between you two. You solve it among yourselves. We are the public at large. We are concerned with only the money. Honorable Court has given us the money.
Yes.
Sanction is there. Pay us my due.
Yes, yes.
And later on, you decide on disputes. State, mighty union, decide on the state. Why are you keeping us high and dry? Why don't you pay our money? They are still writing letters of this regard. Now, this is the problem that they are facing. After this, now if you also come to the affidavit, I have called for in the morning.
So the others.
This is
Okay.
I filed it now.
Yes, yes.
Yes, Lordship. Now, Lordship has seen the last order of this Honorable Court of 24-1. It says, whatever dispute you have, try to resolve it within this day. If you don't do it, then we will be constrained to pass orders for disbursement. That was the Honorable Court's order, the last one. In the meantime, under an RTI, we have been able to obtain the office notings of the file where they are handling this issue. So this is very relevant, and therefore I need to place them before your lawsuits. Lawsuit will kindly come to page 7.
Yes, page 7.
Yes. Now this is the type copy. If it is not otherwise inconvenient to a lawsuit, if a lawsuit will see the original at page 8, because that is more, that gives the better picture actually. Instead of type of page 8. Now, the first noting, page 8, may kindly peruse. Now, this noting is given by the Commissioner Secretary of the Department of the state. May please peruse. MORD has accorded sanction subject to the condition that the amount shall be recovered from the agency charges of the state PWD Nagaland. This is on 3/11 now. Lordship has seen on 27 October, the sanction came.
Yes.
And on 3rd of November, the commissioner, he puts up a note. Lordship will see at the left-hand side column, left-hand side of that note.
This is for the funds to be released. All these
Yes,
notes
this is
are.
very relevant because where they have been stopped, I'm just placing that. If you also will see the left-hand side, this note has been put up to the Deputy CM and Minister, NH. So it's
Yes.
yes. On the left-hand side.
Yes.
Yes.
Deputy CM Minister.
Deputy CM Minister, yes. So the Commissioner Secretary puts up this note to the Deputy CM Minister of the National Highway State. He says that MORD have sanctioned the money, but there is a condition of recovery. The minister, that bold, discuss, it was also in that discuss. This is the minister's signature.
Yes, yes.
So it came on 15/11. Minister has said discuss. Now, if your lawsuit will finally come.
So you get this through RTI?
Yes, lordship. Notes are available nowadays.
Okay.
RTI letter is not there.
Huh?
RTI application is not there.
I have categorically stated in paragraph.
No, RTI application is not there.
What RTI? What is not there?
RTI application, my application.
RTI application.
Again,
It is
lordship
not
is
there.
trying to dilute the
Yes,
issue.
yes.
The issue is
Unless
not
and until RTI is filed, how
Is
can
he
he
denying-
obtain
is
the
he
official
denying-
documents
is he
like this?
denying this? You will not
It's
deny
not
this.
possible.
Under RTI did not obtain.
He has
Yes,
all
yes,
the
yes.
machineries.
Yes, I have
He
to.
empowered the state machineries.
Let me just place Lordship. Let me not object, Lordship. I'm coming to my end, Lordship, almost.
Yes.
Now, if your Lordship will kindly come to page 12. I'm not troubling your Lordship with the other noteship issues. These
Yes,
are all
yes.
like here and there, from here to here.
Yes, yes, I
I'm just placing
understand.
the minister.
I understand. This is like a register. They keep on placing it before the minister.
Yes, Lordship.
Mm,
Now, page 12, if your Lordship will kindly come.
yes.
Page 12, again, that bold or deep pencil note,
Mm,
page 12.
yes,
Lordship will be able to,
yes.
Yeah.
I won't be able. You have to read it.
I'll read it now.
Yes.
We may write a letter. This is the Deputy CM now writing. We may write a letter to the
Secretary.
Secretary Mort at the earliest. Letter may go from Chief Secretary, Commissioner Secretary level based on the court order. This is very important because it is also
Yes.
Partition X. In the meantime, payment should be disbursed to the beneficiaries.
Ah,
So the
yes.
Deputy CM
Yes.
on 23/11 says, you write a letter
Mm,
because this is recovery. He understood.
mm,
Recovery will come later on.
mm.
You write a letter, but the money should be disbursed to the beneficiaries. So he is correct to this aspect. Now, if your Lordship will come to page 14.
Mm,
Now, page 14, again the last portion.
mm,
It is signed on 23/11 by the Commissioner Secretary.
mm.
It says, as
Yes, I have
Yes.
seen it. Yes.
Yes, as directed on preface letter to Secretary Mort has been signed. Meantime, file is put up again as noted at X on preface regarding disbursement of the beneficiary as desired by Deputy CM Minister NH. Now below that there is a small scribble.
Yes, yes.
This is by the Chief Secretary. Yes, the payment should be made to the beneficiaries approved on preface by Deputy CM. So the Chief Secretary also says, yes, go ahead, make the payment. So my argument that my brother is now raising regarding this condition of agency charge, these were all before the authorities and the Deputy CM. Still they were saying, go ahead, make the payment. We'll decide on that later on with the ministry. But right now pay. Now if your Lordship will come, how it changed? Page 16.
Mm,
Page 16. Now the Commissioner Secretary on 20/11, after the Chief Secretary have also told him to release, he however again writes to the Deputy CM. Commissioner Secretary, if you Lordship will see at the right hand side, it's addressed to the Deputy CM.
yes.
As desired by the Honorable Deputy CM Minister, matter regarding disbursement to beneficiaries is put up for further direction, please. Now what does the minister says?
Mm,
Now the minister says, we may release payment after seeking legal opinion.
mm,
So now he has a slight change of his views. He says, let me have a legal view.
mm.
He doesn't say don't pay, but he says maybe pay after legal view. Now this is very unfortunate. Page 14 is very unfortunate. I am bound by my duties to my client, so therefore I have to place this legal opinion. But this is against my brother, so but then please excuse me, but then I am bound by my duties. And as the officer of the court, I have to place the facts.
Mm.
Page 17 is now the opinion.
Mm.
Page 17.
Mm. Yes.
I will not read the entire thing.
Mm.
Page 18, if you Lordship will see. Page 18, the last paragraph from between I am reading. However, the condition, Lordship has seen that.
Yes, yes.
However,
Mm.
page 18.
Yes, yes.
However, the condition of Mort sanction order dated 27/10/2023 is in gross violation and contravention of the Honorable Court's judgment dated 31/2023, as there is no direction, observation, whisper from the agencies for recovery from the agency charges of the state PWD, and moreover, the Honorable Court judgment dated such and such has also attained finality. In that, now, therefore, his opinion at page 19. Therefore, in my considered opinion, the state government should make an endeavor, apprise the mort at the earliest to waive the agency charges leveled against the state government before making payment to the affected landowners for damage compensation passed by his honorable. So the standstill happened with this very word before. What he says is, you write letters before making payments. Ask the authorities to get it waived, mort to get it waived before making payments. He says, in my considered opinion, the state government should make an endeavor to apprise the mort at the earliest to waive the agency charge leveled against the state government before making payments to the affected owners. So the legal opinion is that before you make the payment, get it waived, get this agency charge waived. The minister and the authorities are, again, there's a legal opinion coming from the AG, the additional AG. They are going ahead with this. Now, this particular opinion is wrong on two counts. Number one, the Honorable Court order is for payment. The money has been sanctioned. Payment is something else, and recovery is something else. Recovery will be an issue that has to be dealt between them. Payment cannot be stopped. They have not filed a IA in this PIL asking for review of the judgment or for anything in this regard. That he himself has said that in finality. The court order is make the payment within 6 months. 6 months have become 13, 14 months now. So this is one count, it is wrong. Number two, why it is wrong? There is already a judgment of this honorable division bench in another identical matter, wherein this aspect was raised by my brother and totally negated and turned down by the division bench. In the meantime, just one thing before I go to the divisional judgment, only one issue, page 20.
Yes, page 20.
Page 20. This is the letter written by the Deputy Commissioner Peck to the Commissioner Secretary of the Nagaland Department. It says, with reference to the subject above, I have the honor to inform you that as per the Honorable High Court Kohima bench judgment at 31/2023 in the matter of PIL 9/19, the sanction amount of 60.94 has been received from the Ministry of Road and Transport and Highways on 2 occasions by letter dated 5 January and 12 January. In this regard, I would request your esteemed authority to kindly give necessary directives clearance for payment of the damage compensation to the rightful owners. The checks Lordship will find at page 22. One is the check at page 22.
Yes.
This is dated 4/1/2024. 2 months is gone. And the other check is at page 24, 13/1/2024. The checks have reached the Deputy Commissioner and he is asking the higher ups, please give me the clearance because I need to comply with the Honorable Court's order. Now, the situation is this. Now I will place the division bench judgment. Wherein this argument has been completely negated, has been completely turned down. Now, this is the PIL, page 25.
Yes.
As I told your Lordship, the entire damage compensation of 120 crores. We came for a particular area of 60 crores. There is another area, a small area, around 5 crores amount was there. Now, these people have also filed a PI.
Okay.
Now, therein.
Okay, okay. It's the same road.
Same road.
Double lane.
Different stretches, basically.
All right.
So, they had also filed one case, asking for the same amount.
So why this has come before the single bench then? Or this is the contempt petition?
Division bench.
No, okay, okay. This is a PIL.
PIL.
And this is a contempt petition.
This is the contempt petition.
That is the difference.
Our High Court rules, Lordship, it says, even if a judgment is passed by a division bench, contempt matter will lie before a single bench. So therefore, division bench matters
Yes.
also will come before single bench. So now I am placing this judgment because of this issue. So Lordship has seen this is PIL 1 of 2023. Now this matter, page 27.
Yes.
This was decided by the division bench on 7/2/2024. Page 27.
Yes.
After the last order in this contempt matter of 24/1. On 7/2/2024, this matter was decided. If a Lordship will kindly see the names of the advocates appearing, just for the purpose that my learned friend was also there. Third, Consular Sharma for petitioner and LT Sankam, additional AZ for the state of Nagaland. So he had appeared in this matter. Now, if a Lordship will kindly come to paragraph 8 at page 30.
Yes.
Mr. You got that?
Yes.
I'm just reading that also. Mr. LT Sankam, learned additional advocate AZ Nagaland, for the state respondent, submits that against the dismissal of the counterclaim made by the state before the arbitrator, the state has also preferred an appeal for the Delhi High Court and the outcome is still awaited. Now, this is relevant. He further submits that although the mort in connection with PIL 9 of 19, this case for this contempt round, has accorded sanction for the assessed amount, but the same is made with a condition that the amount shall be recovered from the agency charges of the State Public Works Department of Nagaland. The learned AZ submits that the state government is only a supervisory agent and cannot be fastened with a liability to compensate the landowners for the damage caused by the contractor who executed the work. He therefore submits that no liability can be fastened upon the state government for recovery of the amount disbursed to the affected person. So my learned friend had raised this issue in this case also, saying that sanction amount, however, a condition is there, so it should not go ahead.
Yes.
Now, Lordship will come to paragraph 9. I'm just reading the relevant portion. This code, Lordship will see. On the 12th line from below, it starts with the sentence, this code.
Yes.
This code
Yes.
has also informed, this court has also been informed that the state government, pursuant to the sanction made by wards with the condition that the amount so sanctioned should be recovered, so sanction should be recovered from the agency charges of the State Public Works Department, has written letters to the MOD, i.e. letter dated 23/11. These are the letters which is before your lordship now,
Yes.
the one that has been placed. I'm not reading those letters. The learned AZ submits that nothing was reflected in the judgment of this court in PIL 9 of 19, and therefore MOD cannot impose such a condition in the sanction order. The exact argument which he is now raising before this honorable court. Now what the honorable High Court says at paragraph 10. Be it stated herein that the question, yes, be it stated herein that the question of recovery is between the state government and MOD, and the same cannot be an impediment. Lordship will mark that word. Same cannot be an impediment for disbursement of the assessed compensation amount to the landowners concerned. Therefore, the respondent authorities, both the state government as well as the MOD, shall process the matter of according sanction and payment of the same to the landowners concerned without any delay and without waiting for resolving their differences on the recovery of the sanction amount. So the division bench have categorically answered to their objection, saying it cannot act as an impediment for the payment. So today what he is submitting is also contemptuous of this judgment.
Of course, I'll have to abide by the judgment of the division bench.
Exactly. Even if the judgment is not there, even then, the position was recovery, you cannot attach the recovery part with compliance with the honorable court's order. Honorable court's order is a sanction, is a gospel truth. Having not been challenged, it has to be complied. Anything
All
is
right,
there.
then,
So therefore, Lord,
can't help it, we have the DB judgment, this is a single bench.
I'm not confident. My submission there. Therefore, Lord, my submission today is twofold. Number one, there has to be a direction for the payments to be released by giving a date, like within 7 days, the payment has to be released. And if it is not paid, I leave it to Lord, 7 or 10 days. Payment has to be released. And if they do not submit compliance on that day, then the chief secretary and all the contemners should be present before the honorable court to face appropriate orders of this honorable court, which therefore I would just like to place one Supreme Court judgment, one paragraph for your lordship's hand perusal. And also this.
So this is your letter, no? You have submitted a document today?
Yes, madam.
This, you submitted this document? No, no.
Yes, submit the sanction order. Yes.
Yes. Yes,
Yes, Lordship. This is a judgment of the Honorable Supreme Court of 2014. I'm just placing paragraph 35, a contempt case, Lordship. Because Lordship knows Article 215 of the Constitution empowers the High Court to punish a contemptor for orders of this Honorable Court being violated. Now, page 35. Paragraph 35 also. I'm sorry, paragraph 35.
yes, that's the thing. Yes.
Yes. Sufficient opportunities have been given to the contemners to fully comply with those orders and purge the contempt committed by them. But rather than availing of the same, they have adopted various dilatory tactics to delay the implementation of the orders of this court. The non-compliance with the orders passed by this court shakes the very foundation of our judicial system and undermines the rule of law, which we are bound to honor and protect. This is essential to maintain faith and confidence of the people of this country in the judiciary. Paragraph 37 thereafter, we notice, paragraph 37. We notice on this day, also, no proposal is forthcoming to honor the judgment of this court, it is such and such, and order is such and such, by the three judgments. In such circumstances, in exercise of the powers conferred under Articles 129 and 142 for Supreme Court, and for the High Court is 215. The Constitution of India, we order detention of all the contemptors. So therefore, I am just placing this because a lordship may kindly give an observation that these kind of situations may therefore befall upon them. So let them disburse the money within a time frame, which I say the checks are already there because they will now lapse. The RBI guideline also I am holding in my hand. If you also would like to see the RBI guideline.
Yes, yes. Yes, yes.
Yes. This is the RBI's guideline of November 4, 2011.
Yes.
Now simply see the last line. The Reserve Bank hereby directs that with effect from 1st of April 2012, banks should not make payment of checks, drafts, pay orders, bank checks bearing that date or any subsequent date if they are presented beyond the period of 3 months from the date of the instrument. The last line is in that. Earlier it was 6 months.
Yes.
After 2011, this guideline, after the 3 months have elapsed from the date of the instrument, the checks will be stale. No banks can honor it. So if this delay tactics continue, tomorrow I will be in a position that the checks will be stale and everything has to now, I do not know what will happen thereafter. So this is the urgency why I have taken so much time of your honorable lordship today. This is the urgency that we are facing. So therefore, in my humble submission, this honorable court should uphold the division bench order and in this contempt direct them to make the payments within a time frame around, my hope is 7 to 10 days, and fix the matter for compliance And if there is no compliance on that day, they should appear, they should be personally present to face appropriate orders of this honorable court on punishment, as is being done in this Supreme Court judgment. This is my submission.
Small submission. Your
Yes,
Lordship.
yes.
I can release the money today also, but may I pray that the respondent number one reply to our 4 letters within the shortest possible.
This is contempt versus nation. This is contempt versus nation.
This is a contempt case, and as to the direction of the court, we have already sorted the check. We have already paid. Now, if they have any grievances, that is an issue. This is a contempt case.
Yes, yes.
In
Correct,
contempt
correct.
petition number one, the secretary of the concerned ministry is the respondent number one.
We have already paid.
Payment is different, but contempt
How can we
petition,
make this submission now?
No, no.
The government is.
No, it is going in a different direction. Yes, your prayer is going in a different direction.
Very unfortunate, because the Prime Minister says, Section 14 of the Contempt Act says, if someone of the case of the High Court makes a kind of statement, they can be booked for contempt today. Here itself.
Court said.
Section 14. What is this?
Contempt of court said.
He is the additional AG of this honorable court, or of this honorable, he is the officer of the court. The
No,
difference is already
he
there.
is concerned about his own.
No, it cannot be.
No, no. He's submitting, he has to make the submission.
He is the officer of the court at the foremost.
Yes, yes,
First
that
of
is
all, he is the
the.
officer of the court. The
Only
difference
then I'll
is
pass an
clear.
order. I'll pass an order. I'll have to follow the order of the division bench. I cannot help it.
yes.
How can he make a submission like this? Section 14 makes him contempt.
No, no, no.
Very unfortunate.
No, no, no.
Very unfortunate.
He is making submission because your letters are not being answered. His letters are not being answered by the UOI. That is
Yes.
why he is making the
Separate
submission.
issue.
That is a separate.
I understand that is getting deviated, but he.
That is within the state and the.
Exactly. He is the responsible
Then,
officer. He is the.
lastly,
AG.
recovery part.
Very unfortunate.
That ministry, MORT has to make some
How can we
endeavors to
recover
reply
the
his
entire
letters.
amount from the agency charges?
These are issues beyond this court proceeding. They will politically, political way they will do it, whatever they have to do, not something that this honorable court has to look into. Most of the review method.
All right,
Oblige selection.
I'll pass the order now because we do not have time actually. The money has to be released.
Yes, sir. Exactly. And deeply obliged.
Mm. So please don't hesitate to interfere if I'm going in some other direction. Please don't hesitate to interfere. Heard Mr. A. Sharma, learned counsel for the petitioners. So there are many petitioners, I believe, 4 of them, no?
4 of them.
Petitioners, 1, 2, 3, 4. You write down the names, sir.
1 and 3.
1 and 3 years.
That is responded.
So petitioners, Chakesang Public Organization, then Paprumo Demo, Besupra Suro, and Jovenhu Lohe. Comma, heard Mr.
LT Sanctum.
LT Sanctum, learned additional advocate general for who are respondents?
Respond number 2, Lords.
For only respondent number 2.
Yes.
And learned counsel, Mr. V. Jimha.
Yeah. Yeah, no.
Yeah, okay.
For 1 and 2.
Is item number
17.
17. Okay. Please write down. I didn't get your name. For the respond number 1, 3, 1 and 3. The petitioners have filed an application under section 11 and 12 of the Contempt of Courts Act, read with Article 215 of the Constitution of India, for deliberate and willful violation of the judgment and order dated 31 Trees Act 31 2023 passed by this court in PIL number 9 of 2019, passed by a division bench of this court
Yes, Lordship.
in PIL number 9 of 2019. It is submitted that during the construction of the double laning, what is a two laning? During the construction of the two laning of LONG Longlang hyphen Changtongya Road at Mon hyphen Tamlu hyphen Meranglong Road, comma Phek hyphen PF UTSERO Road and Chakabama hyphen Juneboto Road totaling 320 kilometers in length in Nagaland under the SARDP hyphen NE, comma, several the petitioners had suffered from damages of their properties and farmland, including residential houses also. The petitioners were compensated by the order dated. This is the judgment, no?
Yes, that's it.
Which
Compensation was not there, assessment was there.
Okay,
So we
okay.
had filed stays.
not compensated, yes.
Petition
By
was not
by judgment and order dated, where is the operating part?
At page 21.
You are
Yes.
yet to receive the compensation.
Yes.
Yes.
Yes, Lordship. Way back from that time, still fighting. Page 15, the judgment starts,
Mm.
and page 21, last paragraph is the operating portion.
By judgment and order dated 31 2023 in next para, huh? PIL number 19 of 2019, no? 9 of 2019. It was directed that
Quote that paragraph.
paragraph number,
Page 21, the last paragraph, page 21
page 21, no?
of the contempt case.
Page 21 of the contempt case. No, no, it is not page 21. You quote the para numbers?
There is no paragraph given in the judgment.
1, 2,
Lordship,
3, there are 3 paragraphs.
Lordship,
9 of 2019? Yes. 9 of
Page
2019.
21.
This is the contempt petition? No, page 21.
Contempt case is 19.
Hmm.
Page 21.
Oh, yes, yes.
Yes, Lordship.
Admittedly,
Admittedly, yes. So that paragraph is operating, that will be quoted.
okay. Which is quoted herein below verbatim. I'll change, there'll be a little bit of tweaking and tinkering of the orders.
Yes, yes.
So page 21 of the judgment, blue tick part, huh? Blue tick. Admittedly, the the damage caused to the lands and properties have been already assessed by conducting a joint survey. I'll dictate it, huh? Reproduce herein below verbatim. Admittedly, within inverted commas, admittedly, comma, the damage caused to the lands and properties have been already assessed by conducting a joint survey, and even the quantum of the compensation amount to be paid has also been determined under the leadership and supervision of the deputy commissioner concerned. As such, comma, the state government shall make the first move by submitting a proposal along with the assessment made to the central government, stroke the ministry concerned, comma, and on receipt of the same, the latter shall initiate the process for allocation of fund and release of the same. All right, it's going very fast. You'll copy it from here. All right. then. Page 21 and 22 of the contempt petition. Within the blue ticks, double blue ticks. I'll tag it also. Blue tag, okay? It was, the compensation was, amount was assessed to the at rupees 60, 94, 36, 685, okay?
Yes. Let me put that section already. First edition, 24.
Additional affidavit.
Yes, the first affidavit of 2411. Phase 4.
Yes, yes.
This is the section.
The petitioners have also filed an additional affidavit and annexure 1 of the page 4, no?
Phase 4.
Annexure 1 of the additional affidavit is the sanction order of the MORTH, Ministry of Road Transport and Highways, within bracket, MORTH for short, bracket close, of NER zone, dated 27/10/2023. Full stop. Rupees 60, 94, 36, 685 was sanctioned. To compensate the damages to compensate the loss and damages incurred by the petitioners.
As per the Honorable High Court.
In compliance of the order of this court in WPC number 9 of 2019.
Yes.
By the order dated 23/1/2024, a last opportunity was afforded to the respondents, contenders for resolving the issue between the MORTH of India as well as the government of Nagaland, Works and Housing Department. And if the issue will not be resolved, necessary orders would be passed to disburse the compensation sanctioned by the MORTH to the affected landowners. The learned counsel, the learned AAG, has drawn the attention of this court relating to the per contra, the learned AAG has drawn the attention of this court relating to the
communication letters, Your Lordship. One, I have misplaced, the
Yes,
second
yes.
one will be.
Relating to the issue between the MORTH, Government of India as well as the Government of Nagaland.
Yes, ma'am. Full state.
They have raised objection that for just a moment. The objection is in the judgment, no?
Yes.
Your Lordship, if I may be allowed to mention, later dated 23rd November 2023, written by the Commissioner Secretary, first announcing, and 21st December 2023, later written by the Chief Secretary, letter dated 12th January 2024, written by the Deputy Chief Minister and Minister of National Highways, and letter dated 17th February 2024. Your letter written by the Honorable Chief Minister may kindly be reflected.
Yes, I'll refer it. Letters.
Already
All those
referred in
letters.
that judgment.
Huh?
Already referred in
Recent-
itself.
Recent
Yes,
one,
yes.
recent.
So I'll just cut copy the judgment.
Yes, ma'am.
I'll just cut copy the judgment. Which paragraph? Which paragraph of the judgment? Huh?
Paragraph 8,
Paragraph 8.
My submission may,
page 30 also. Page 30.
my submission may kindly be recorded.
Yes, yes.
And
That is what
last-
I'm.
Last letter, there are two letters. One letter is latest, that is.
The
order
last
from
letter
Chief-
I'll refer.
Honorable Chief Minister. Yes, ma'am.
The last letter I'll refer. Mr. LT Sanctam, no?
Yes, madam.
The has raised objection, stating that although the mort in connection with although the mort has accorded sanction for the assessed amount, but the same is made with a condition that the amount shall be recovered from the agency charges of state PWD of Nagaland. It is further submitted by the learned AG Mr.
LT Sankam.
LT Sanctam that the state government is only a supervisory agent and cannot be fastened with a liability to compensate the owners for the damages caused by the contractors who executed the work, full stop. He has also submitted that no liability can be fastened upon the state government for recovery of the amount disbursed to the affected persons due to the issue between the state government and the mort. Several letters were written by the ministry.
By the state government.
By the state government to
Yes,
the,
ma'am.
to the
ministry.
mort.
Yes, ma'am.
To the mort. The learned, Mr. AAG has. This is also, you have annexed this, no? The letter there 27/10/2023.
Your lordship,
It is there in the judgment also.
Yes, okay.
Judgment has noted all those letters. Paragraph 9, page 31, that last portion, this court has also informed from there.
Oh, yes, yes.
Those letters, all those letters.
Yes, yes. This
Yeah.
court, I'll just copy this.
and the latest
This-
letter written by the Honorable Chief Minister on 17 of this. month.
That last one I will include it. This court has also been informed that the state government, pursuant to the sanction made by the mort with a condition that the amounts of sanction should be recovered from the agency charges of the state PWD has returned back to the mort. While letter dated 23/11/2023 by the Commissioner and Secretary to the Government of Nagaland, letter dated 21/12/2023 by the Chief Engineer to the Government of Nagaland,
Your lordship, 23rd November,
letter dated
23rd November, 2023.
23rd, that's what I have mentioned, that I have just mentioned. A DO, letter dated 12/1/2024 by the Deputy Chief Minister.
Yes.
Where is this letter dated?
17 February.
No, 12/1/2024.
By the
12 is by the Deputy Chief Minister.
by the
Ah.
Deputy Chief Minister.
Yes, yes, I got it.
Last one
A
is
DO is what will be the DO?
PO
Huh?
number.
DO number, a DO number DCM stroke A stroke 69 stroke MORTH stroke 2024 dated
January
12 January 2024, written by the Deputy Chief Minister to the MOT. No, directly to the minister,
Yes, Your Lordship.
directly, yeah.
They are writing letters.
To the minister, comma, to the honorable Union Minister, Ministry of Road and Transport, Highways, New Delhi. It is further and letter dated, last letter,
17 February 2024.
17, and the letter dated
17 February.
by the 17
Honorable
February
Chief Minister.
2024 by the
Chief Minister.
by the Honorable Chief Minister to the MOT. Secretary MOT, no?
No, Your
Not
Lordship.
direct to the minister,
Honorable Minister.
to the minister.
First and second letter was,
Again to the minister. Again to
first
the-
and second letter
again
was
to the
written to the
minister.
ministry.
Comma, Ministry of, what is this full form? Ministry of
Road,
Road,
Transport and
Transport and
Highways.
Highways. It is further argued that
Para 3, Your Lordship.
that MOT cannot impose such a condition in the sanction order. Alright? Had Mr. Yangavati, learned counsel for the UOI, no?
Yes.
Learned counsel for the UOI, comma, who has submitted that two checks have already been issued. And it is on the state government to disburse the money in favor of the petitioners. I have considered the submissions at the bar with circumspection. The MOT has already disbursed rupees 60,94, 36, 363 or 685. I've considered the submission that the checks were issued on 4/1/2024 and
Yes. And 12/1/2024.
and 12/1/2024. The additional an additional affidavit has been filed today on 29/2/2024 by the petitioners. And the annexure number,
Regarding the checks from.
yeah, yes.
Annexure 3,
Uh,
page 22,
The annexure 3 are the checks.
page 22.
Annexure 3 of the additional affidavit are the checks dated 4/1/2024 and
12/1/20.
12/1/2024. This is the annexure 3, no?
Yes, Lordship. Annexure 3, page 20.
Annexure 3 of the additional affidavit, huh? Are the checks dated 4/1/2024 and 12/1/2020, 12/1/2024. The decision of a division bench of this court in PIL number 1 of 2023 is relevant to this case. It has been held, in PIL number 1 of 2023 that
Same argument was made by the AG.
Hmm.
Same argument was made by the AG. However, at paragraph 10, it was rejected.
No, I'll copy it. Whatever has been mentioned, held, I'll
Yes,
copy it.
Paragraph 10. Paragraph 8 is his argument and paragraph 10 is the answer.
So you go to this affidavit dated 29 February 2024, and from the part, the red tick, you copy it. Page? Page? This is page 31. 31 and 32. Red tick part, you copy it. Red tick, There is a blue tick also, but don't you copy on the red tick part. Paragraph 9, the lower part. Paragraph 9, the lower part, and paragraph 10. In the wake of the foregoing discussions, the petitioners are thereby directed the petitioners, the respondent, the state respondents are thereby directed to comply with the decision of this court in PIL number 9 of 2019 and disburse the and release the amount.
Release the check amount.
And release the check amount which has been issued by the UOI
Yes,
in favor of the petitioners. Anything added to be added for on your part?
Lawsuit must give a timeline within 7 days.
Within 1 week.
Within 1 week.
Within 1
Because
week.
otherwise they will become stale.
Within 1 week from today. I will add it somewhere in between, considering the fact that the checks have been issued as issued in the month of January.
So one more thing.
So I'll hold it here and
one more thing, Lawsuit will fix this case on a particular date
Mm.
for compliance. Again, if they don't comply with this order, I will be remediless thereafter.
okay.
I cannot file another contempt. So let it be fixed on another date,
All right.
maybe on 15th of March. Let it be
Yes,
fixed.
yes.
And on that day, they have to submit compliance report. Otherwise, the state respondent has to be personally present. That must be also added because they are already possible seen. They have this judgment is there and he's still arguing that we should not pay. This is the body language now. So I'm really fearful whether they will be complying or not.
No,
I'm really fearful.
they will comply. They will
So
comply.
therefore, lawsuit will
The
just-
money is already before them. Then
Yes.
Still they're not doing it.
they have the funds.
Because of the
Only the
condition,
realization they are
because of the
confused.
condition. Your
They are,
So lawsuit will fix it on 15th.
they have a remedy. They will have a remedy
That
in
is
a
for them to
in a
decide.
different manner, not through this, but
That is for them to
list the
decide.
matter on 15/3/2000
For compliance.
for report,
Compliance.
compliance report.
For compliance report.
For compliance report.
And also I request your lawsuit to add that. And if they don't comply, their
No.
they should be present on that.
You don't have to be apprehensive. Then they won't comply.
So the,
You have to be certain that they will comply.
Lordship has seen the situation that we are faced, this long battle for a new money, a money that has been accepted by them. We are
So
still-
what about the other case, division bench case, PIL? Have you paid the money? That has been disposed.
No, not paid.
Not
That is, then another contempt will come.
This is the first one.
What are another contempt is coming? Oblige, Your Lordship.
Yes, yes. The money is there, but we do not know where it is. And they do not know where to get it from.
Yes. The money is in Canara Bank. The check is issued from Canara Bank.
That is always there.
Oblige, Your Lordship.
For admission, item number 18.
Pin it up and give it to her. Yes. Yes.
Lordship, in this case, the respondent number 2,
Mm.
he has been transferred at a new incumbent has been appointed.
Mm.
So, since this is a contempt petition, let them file an implement for the new incumbent,
Sorry?
for implement of the new incumbent.
Okay, okay, okay.
The respondent number 2 has been transferred,
Okay, okay, okay.
so there is a new incumbent.
Okay, new incumbent.
Well,
Respondent number 2 is IS officer.
It's a brigadier, army. case.
Army, okay,
Yes,
okay.
Lordship.
Okay.
So, the new incumbent is one Mr. Brigadier Amitabh Roy, the new incumbent.
Contempt petition.
Well,
Yes. You are a petitioner.
No, I'm for the response.
Respondent. Sorry? Oh, for that implement, okay. Okay. It is submitted by Younger Mati, no?
Yes,
Learned Council Younger Mati, or why Younger Mati?
Younger Wati,
Younger Mati,
CJC.
CGC,
Yes,
CGSC.
no,
Learned CGST is SC, why Younger Mati for the petitioner?
For
the-
the
oh,
response.
oh, For the
for the response.
respondents and Miss Learned Council for the petitioner that the respondent number 2 has been transferred and time may be allowed to
Into the new incumbent.
implement the new incumbent as respondent number 2.
3. That's 3.
Respondent number 2 or 3?
3, Lord.
3. All right. As respondent,
Well,
2 or 3, you will decide. And time is also allowed to file a amended cost title. Oh, no, time is allowed to file an IA. All right.
Item number 19.
May it please, my lord.
Yes.
As directed by this honorable court by order dated 29th of September 2023, I am fully complying with the directions of this honorable court, and then I will comply with the directions issued by the investigating agency. I have also activated PR bond for the concerned police station. And my prayer before this honorable court is that the anticipatory bail order, which has been granted to me earlier, may kindly be recognized, because I have duly followed all the conditions laid down. And even otherwise, this is a sort of a frivolous case being filed between the sister-in-law and the applicant. It's a family dispute, so yeah, all parties are trying to resolve it.
Yes.
Lordship, as far as the latest status report is concerned, that is. That is.
Okay, okay. Then we'll extend the interim period then.
Next week.
Next week.
In fact,
Hmm.
it's a very trivial case.
No, interim order will be extended. All right. Heard learned counsel Mr. Sentiangar, no? For the petitioner,
Yes.
and learned, K, learned PP, Mr. B. Jumomi, for the respondent's state. The learned PP has submitted that, status report is yet to be received. List the matter after list the matter on.
After 2 weeks in that case.
Yes, all right, 2 weeks, yes. 11/3, list the matter on 11/3. Interim order shall 11/3/24. Interim order shall remain in force till then.
Deeply obliged.
For orders, item number 20.
May I please?
Yes.
I thought, the High Court legal service put the High Court in need as
Mm.
investigated.
Mm.
Today, it is the matter, I is listed for to condone the delay. It's a delay action. My lord, we see from paragraph 3, how they have explained for that.
Paragraph 3, this is a delay. Paragraph 3 of the I. Yes. Yes.
That the interim judgment order was passed on 26/7/18 by the district session judge Sanhabote. The time limit to file criminal appeal against the conviction is on 6 days from the date of judgment as per the Military Act 163. That counting from the date of judgment, 60 days was completed on 24/9/18, and the delay was run against the applicant from 25/9/18. However, the Secretary High Court Bar, High Court legal.
So just a moment. We have to issue to notice to respond number 2, because this is a case under POSCO Act. Then only we can condone the delay. All right.
Notice, the period of notice is awaited.
Oh, notice is awaited. Respond number 2. So if the notice is served and if she is not represented, we can take up the matter, but notice notice on respondent number 2 is awaited. I may lico. Notice number on respondent number 2 is awaited. List the matter after how many? 2 weeks?
Because the man is in jail.
Yes. And you have been appointed in appeal?
Yes. I mean.
No, appeal is not, there's an order maybe?
Yeah, that's. Money.
For orders, item number 23.
The plaintiff has not taken steps. Parties are not represented. The parties are not, appellant is not represented. Today, no steps has been taken. Office note dated 27/2/2024 indicates that no steps have been taken to issue notice. As upon respondent number 1 to 3. List the matter after 2 weeks. Yes. Time 1 minute or clearly.
Item number 24.
Last order, this honorable court has directed the admin company to take first steps on the respondent number 2 and 3. And then comply with that order. The service is still awaited.
It's awaited, yes.
Yes.
Service report on respondent number 2 and 3 is awaited. List the matter after 1 week, 2 weeks.
Worship, in this case, if this honorable court may allow us to take step through substitute means by way of
All right.
paper publication.
Yes, is still awaited. The learned counsel for the petitioner has prayed to take to take steps through substitutional
Substitute means by way of paper.
substituted means. The petitioner may take steps. The petitioner is allowed to take steps to issue notices to the respondents number 2 and 3 through substituted means. List the matter after 3 weeks.
Right. Much obliged.
Item number 25.
Watching the last occasion, we have raised a substitute for this two with speed post. That was done and the service report is awaited.
All right. Petition, service report or respondents. What sole respondent?
For the petitioner.
Okay. Service report is awaited. Is the matter after 2 weeks, 3 weeks? 3 weeks.
For motion, item numbers 1 to 3.
Lordship, item number 27, I am waiting. 27 item number.
20.
27, Lordship.
27.
Yes, yes.
I don't know that.
I think and for the appellant in 27, Lordship. There's a delay condonation petition for restoring application. I think, Lordship, we have taken steps. Service is awaited, Lordship.
Okay, item number 27. Okay.
Yes, your Lordship.
Notice issued to respond number 5 and 6.
Yes, your Lordship.
Service report is awaited.
Lordship.
All right then.
Lordship.
Report on respondent, service report on respondent number 5 and 6
Lordship.
is awaited. List the matter after 2 weeks.
Lordship, let it be after 3 weeks, Lordship.
List the matter after 3 weeks.
Oblige, your Lordship.
Yes.
May please, Your
Mm.
Worship.
Mm.
This application is being filed for allowing applicant respondent number 1 to withdraw 50% of the awarded amount deposited by the appellant in terms of this honorable court's order dated 20 November 23, passing IA Civil number 136 of 2023 in appeal number 9 of 2021. Lordship, the applicant being a permanently disabled person, he is living in a great hardships for maintenance and livelihood. As such, pray before this honorable court to allow the applicant to withdraw the said 50% deposited amount, considering the applicant's right and hardships condition, as hearing and disposal of the appeal shall take considerable time. Lordship, I have annexed the orders 20 November 23 as annexure 1. Your Lordship may please turn to page 7 of this application. Last paragraph,
Having heard the submission of the learned counsel for the both the sides, the operation of the impugned award dated 4/2/2021 stands subject to the conditions that the applicant has to deposit 50% of the awarded amount before the registry of this court within 1 month from today. Then, Your Lordship, the appellant has deposited in compliance with this order 50% of the awarded amount. So, Your Lordship, may please turn to page 9 of the application. Second, last paragraph. In compliance of the order dated 20th November 23, the appellant has deposited an amount of rupees. Your Lordship, here, the amount is written as 7,64,500, but it should be 6,09,650. Before the registry, being the 50% of the awarded amount in MSC case 85/4.
It should be 6 lakhs. How much? It should be how much? 6 lakhs?
6 lakhs 99,650.
6,99,650. All right.
99,650.
So you want to withdraw this amount
Yes, I pray before
through this petition? ICIA 21 of 2024.
Yes.
Yes.
I'm referring on behalf of the appellants. Lordship, since we are issuing the impugned order, so if the Lordship grants the withdrawal, then proper identification and proper address proof maybe to the satisfaction of the registry of the honorable court.
Yes.
That is the only condition.
I'll come back and pass on the order. So I'll allow it after proper verification and proper. So do you have children?
No.
Children? No.
No.
You are?
Bachelor.
Bachelor.
Yes.
Okay. So for whose death you have received this compensation?
Oh, it is.
Accident case, injury case. Okay.
Permanently disabled.
Permanently
After this
disabled.
accident.
Okay. Okay. So do you, why you are preferring an appeal?
Because at the time of the accident, the vehicle was not flying without proper route permit.
Oh, route permit.
Yes.
Okay, okay.
And
So,
also-
okay, okay.
And also the compensation amount
Is
that's
higher.
also we are receiving. So.
So route permit, there are judgments that it may not, you may not, appeal may not be allowed also. There are judgments also. But on the higher end, if the compensation, it can be reduced.
Yes.
So it can, I think compensation can be paid, I think so.
Yes.
So I'll come back and pass an order.
Okay.
Your Lordship, there is a similar case, item number 3,
I'll come back and I'll,
with the same condition.
oh, same condition.
Yes.
Between the same parties.
Yes. Same party, but amount
Same
is
order.
different.
And this is an accident case, permanently
Yes,
disabled.
yes, yes.
That's why there are some.
Both
Analogous,
analogous case.
yes,
Okay, that both became permanently disabled in the same accident.
yes, but the
Okay.
amount awarded amount is different.
Okay.
So in the second case. it
So
is
that
7
there
lakh.
is no dispute about the amount. Here you have a dispute about the amount. In the
No,
second case?
Your Lordship, in the order,
Ah.
passing the order, the amount is confused.
Yes, yes, you have to calculate it, no?
Yes,
So in the
But-
second case, there is no dispute about the amount.
yes,
50% is correctly
yes,
assessed.
50%, as per my application.
All right,
That application amount is correctly written.
all right.
Sure. About the amount. In one case, it's 6 months.
Achambemo is 6,99,000, then officer told is 7 lakhs.
Officer told is
7 lakhs. Yes. And
We have deposited the.
no, say you have deposited both, only
only the order has reflected the wrong.
Oh, order has reflected that.
Wrong. See, order yun wrong there. Approve order here no wrong there. A chamber of view no lero 7,64,000. It should be 6,99,000. So you go back. You have price. The court.
Yes, sir. Well, we have no dispute, so if you're not feeling well, so possibly we can dispose of it. At two.
No, sir. Order parts of the yes, reflection.
Okay. When it was,
The other way around. Yes, yes. So, okay. Oh, this is. Okay, itu lalu, ini part-time dulu, terus.
Notice due to this already, because we have already taken substitute notice now, by way of obligation. Because.
Already taken this one for another motion.
This is another possible.
Because dulu justice servo here and they have.
Well, I will.
Yes, fine. Okay, sir. Okay, sir. ผมเอาปืนถึงได้บอกว่าเต้นทางได้เอาปืนเราเอาปืนเราเยอะสักแค่
वो कहाँ है कोर्ट मास्टर ये सेक्रेटरी पहले सेक्रेटरी को फर्स्ट यू कॉल द सेक्रेटरी Secretary? I. This is item number?
Lordship, 1 to 3.
1 to 3.
Yes, one is already heard and 3 is there.
So item number
3.
three. Where's 3? 1 is here, 2 is here. Huh? Okay. Item number 1, heard heard Mr. N. Meek,
Yes.
learned counsel for the applicant, and Mr. Z. Kunu, no?
For the
Learned counsel for the appearance hyphen opposite party.
Yes.
Oh, yeah, hyphen opposite party. Herein. The respondent number 1 stroke applicant has filed this application. That by order dated 4/2/2021, compensation of rupees 13,99,300 was awarded in favor of the applicant hyphen respondent number 1 hearing in MAC case number 85 of 2015. The learned counsel for the appellant has submitted that a sum of rupees 6,99,650, which is 50% of the awarded amount, was deposited before the registry of this court by the opposite party hyphen insurer, by the opposite party insurer. The applicant has prayed before this court for withdrawal of the 50% of the awarded amount as the applicant hyphen respondent number 1 has been rendered permanently disabled by the accident, which is the subject matter of the subject matter of the MAC appeal number.
9 of
Uh,
2021.
MAC appeal number 9 of 2021. After considering the submissions at the bar, the prayer of the applicant is allowed, the applicant, the registry to allow the applicant, the registry of this court to allow the applicant to withdraw an amount of rupees 6,99,650
650.
after proper verification and identification of the applicant. And that same order will be passed in this, only the amount will be different.
Yes, only amount is.
And case number.
Case number 1.
Item number 2, IA number,
Three.
same order, खाली amount to or case number to भर दिया advocate to same है. Yet a amount, what will be the amount? 7,64,500. Our case number habo MSC
84.
10.
Oh,
MSC case number 84 of 2015.
yes, and MSc appeal 10 of
And our appeal hall MSC appeal
10
10 of 2021. Anything else?
No.
No.
much of that.
So when will you, this appeal will come up after, when will the appeal come up?
After 2 weeks.
List
Because in
the,
the previous order, in the MSc,
uh,
4 weeks time was granted.
oh, yes. List the appeal after 2 weeks.
Much obliged.
For hearing item number 29.
Both the IAs are disposed. Interlocutory application for item number 1 and 2. Interlocutory applications are disposed of. Item number 29. Yes.
Additionally, Lordship, by order dated 12/12/2028, the LCR was called for preparation of the purple book. However, now the investigation agency needs record for further investigation in state crime police station case number 2005. So my prayer is, can we
Scan copies?
yes, if the original been sent back and by retaining the scan copy in view of the.
So we have the LCR.
Yes.
We have the LCR.
Yes, are there in original documents. So it can be scanned, the originals may be sent back.
All right. Item number
29.
9. So we'll defer the hearing or we'll take up the hearing? It has to be, paper book has to be prepared.
Yes,
Under preparation.
yes. After completion of the paper book.
We haven't received the applicant list, right? We haven't received the applicant list. Only after receiving the applicant list, we can get the paper books. Applicant list is required.
What is required?
Applicant list. Applicant list to make the paper book.
Okay.
I'll take necessary steps,
Okay.
my lord.
Learned Counsel, Mr. Senti Younger
My lord.
is present on behalf of the petitioner and Mr. B and Mr. K. Angami, Learned PP is present on behalf of the Learned additional learned PP.
PP.
Learned PP is present for the respondent state. It is submitted that the LCR is required by the
Investigation agency.
investigating agency for to proceed with the investigation of the case. Send back the LCR after obtaining the scanned copies of the LCR.
Yes.
Registry to retain scanned copies of the LCR and send back the LCR. And the learned petitioner to take steps for
Preparation of paper book.
uh,
Let the matter be listed after preparation of the paper book.
let list this matter after preparation of the paper.
For hearing item number 30.
First, I'm making a mention on behalf of Mr. Regularization, London CTC. Lordship, if this item may be listed after 2 weeks, Lord.
Yes, learned counsel, Mr.
Regularization.
Yan, your name, your good name?
Zed Kun.
Z.
Zed Kun.
Kono.
Yes.
On behalf of learned counsel, Mr. Yangawati has prayed for adjournment. Yes, you were saying something?
Yes, notice has been completed, so.
It is also submitted that the notices have been received by the respondents.
Paper, substitute notice has been completed.
It is also submitted that steps have been taken. It took the last to Katiriba, received by respondents to Katiriba. Steps have been taken for to serve the notices to the respondent through paper publication.
Yes.
Okay. So this will come up.
After 2 weeks.
List the matter after 2 weeks.
Right.
Good.
For hearing item number 36.
31.
36.
Nobody is representing. Item number 36.
35.
35?
Adjourn for 1 week.
35.
Yeah.
Somebody has taken adjournment maybe without your permission.
35.
My lord, the council are here for the council.
35, item number 35.
Yes.
All right.
Item number 35, my lord. My lord, here my case is that the petitioner was appointed as workers level fixed pay rupees 300 per month under the establishment of PWD Kifri division, my lord. Annexure page number 13 is the appointment order. Married, my lord.
Yes.
Office order dated 4 June 1987. In the interest of public service, Mr. Chidung Se, son of Sayangkia Sindom of Amadu village, is hereby appointed as the work charge level of rupees 300 per month under PWD Kifri division with immediate effect. The appointment is purely temporary and is terminable from service on serving 1 month notice, my lord.
Yes.
And my lord, after serving for 35 years, my lord, after serving for 35 years in fixed pay, vouchers fixed pay, I was released from service, and the release order is at page 14, annexure B, my lord, and type copy is at 14A, my lord. This order, my lord. Office order dated Kifri 26 April 2022. In terms of section 3.1 and section 3.2 of the Nagaland Retirement from Public Employment
Second Amendment Act 2009, which comes into effect from 31st October 2009, and in terms of Government of Nagaland PNAR Department notifications number so-and-so, there is 7 August 2009, Street Sidong Se Walk Church Level Court number, PWD so-and-so is hereby due for retirement on attaining 35 years of service on land of service, retiring with effect from 36/2022. My lord, with this order, the petitioner was retired from service without granting scale of pay and without regularization in the service, my lord. So, my lord, after my retirement, after the retirement of the petitioner submitted representation to the respondent number 3. Annexure C is the representation, my lord, filed by the petitioner, page number 51. Married man.
Yes.
Yes, to the Chief Engineer, Public Works Department, RNB Nagaland, Kohima, subject representation. Sir, in inviting your attention to the above referred subject, I address you as mayor and the one that I was appointed as workers level order bearing number so-and-so dated 4/6/1987 at the fixed pay of rupees 300 per month. That I have been serving the department for nearly 35 years and will be retiring from service on 36/2020, and I've served the department throughout my life, like any other regular employees, with utmost sincerity, and will be retiring soon. For that mention may be made that numerous orders has been passed by the state government to consider the case of the similarly situated employees, thereby enabling the fixed employees to draw pensioner benefits. In view of the above facts and circumstances, I pray that the authority may kindly consider for regularization of my service so as to avail my pensioner benefits, my lord. This is the representation submitted by the petitioner. However, the state respondent has not considered the case of the petitioner, and the petitioner has come before this honorable court, my lord. And my lord, here I'm relying on the writ petition where similarly situated person have been granted granted.
So before he was released, he has filed his representation. Before he was released, he was filed his representation. He was released on 26
April 2021.
And this representation was filed
19/4/2022. Yes, before his retirement.
Okay, before his retirement.
Before his retirement.
19/4.
19/4, yes, ma'am.
Okay.
And my lord,
you are relying on the order of this court.
Order of this court, yes, my lord.
Where is the relevant portion?
My lord, may I read the whole?
No, not even.
What will it show?
This is a long judgment.
All right.
Only the relevant part will suffice.
Page 22, my lord.
Yes.
Paras.
Yes.
In the present case, in hand, there is no dispute that all the writ petitioners were appointed as labor on fixed pay by the respondents, and that they have continued in service for 35 years before being superannuated by the common order dated 25/4/2013, issued by the subdivision officer, Public Works Department, PWD Housing, Twensan, Nagaland. By the said order, all the 3 writ petitioners are shown to have completed 35 years of service with effect from 31/7/2010, 31/7/2012, and 31st/8/2012, respectively. This court has also considered the CCS Pension Rules 1972. Further, the reliance placed by the learned counsel for the parties has also been considered by this court. This court has also considered the length of service rendered by the petitioner in their respective posts before being superannuated with effect from the dates as indicated herein above. It is seen that the petitioners had been in continuous service through, though under fixed pay for 35 long years, and they had given their prime time of their life to the service of the state government. The state, being a mortal employer, cannot be allowed to apply the methods of exploitation against such petitioners. After having extracted the best part of their lives, this court is of the considered opinion that the petitioners cannot be allowed to go high and dry after 35 long years of service. The son of the state responded that as the petitioners were appointed on fixed pay and had retired, as such, they are not entitled to pensions and other retirement benefits, appear to be very harsh and inhuman, more particularly when they have sacrificed the best part of their lives to the service of the state government. Last but not least, in the facts and circumstances of the case, this court is therefore of the considered opinion that the state respondent should reconsider the case of the petitioner again. Accordingly, this street petition is disposed of with the direction to the state respondent to consider the case of the petitioners for regularizations of the service only for the purpose of paying pensionary benefits and thereafter pass appropriate orders. That such consideration be done within a period of 3 months.
All right, yes. What do you have to say?
And my lord, as per the judgment and order passed by this honorable court, the state respondent has considered the case of the petitioner, my lord. And I would like to place the orders. The state respondent, herein, my lord, the state respondent has considered the case of the petitioner in WPC 104 of 2014 and WPC 105 of 2041.
This is WPC 96 of 2014.
Yes, my lord. There are three petitioners, my lord, where this honorable court was common order.
Okay. 196, 104, yes. 3 petitions. And 105, okay. Yes. Yes, what do you have to say? Yes.
But during his, when he was in service, he never represented. Taking his grievance. Number two, your lordship, who are the charged employee is an employee which is appointed without any sanction post.
So without sanction post,
Without any
yes.
sanction post. That means since the post itself is not there, how can we regularize? How the state will regularize the service?
Yes.
of the petition? It is impossible.
That is true, yes.
It is impossible because we need the sanction post, a clear vacancy. So without doubt, how can that be? And so far as your lordship again to appreciate, work charge and casual employees are covered by the Nagaland Work Charge and Casual Employees Regulation Act 2001.
Let me see.
2001.
We have the
We can appreciate.
office memo.
Yes, I have that.
Yes.
Lordship, there, the casual and worker employees are defined.
Hmm. Yes.
That is it.
Hmm.
And so far as this, rule two of the central service pension rules, that is.
Rule two.
Rule two of central services pension rules.
Give me the
1972,
CCS.
which was cited by the petitioner.
No.
The synopsis of the petition.
No, in the read petition, it has been cited. CCS rules.
Rule two of the central services pension rules, 1972.
It was taken up in the judgment, but not cited. Yes. Rule two.
It is, yes. It's not applicable to the work action casual employees. What you will find in the preliminary, 1972 rules, in the preliminary definition, your lordship will find. So the case of the petitioner is barred by law, your lordship.
CCA rules.
Yes.
Which rule? Rule two.
Rule two.
Interpretation.
1972 rules.
CCS pension 1972.
No, this is not pension rules.
Pension rules 1972.
Not the pension rules. This is CCS, classification, control and appeal rules. We may have the pension rules also. If it is a compilation. No, this is not a compilation. Yes. Okay, from the library, yes, yes, yes.
It's 72 rules, which has been quoted by the petitioner, is not applicable to the petitioner. Because it is barred. It is barred, casual employees.
So, see, without a sanction post, how can a person's service be regularized?
As per the act, Vogue Judge Act, which my learned friend has submitted.
Only for the purpose of pension?
No, that act is for the Vogue Judge only, Vogue Judge. Without sanction post, a person is not entitled for regularization. However, my lord, the petitioner served for 35 years, 35 long years. And in most cases, similarly situated persons have been granted, my lord. Not only in my case, the one which I've cited, the judgment order which I've relied upon, my lord. In that case also, it's same fact, my lord, same fact, similar fact. And the case of the two petitioners we consider. And also, my lord, the division bench of this honorable court has granted to the similar situated person. My lord, I would like to submit the order.
All right.
My lord, firstly, I would like to take the lordship to the fact, That is page number 2, paragraph 1.
Yes.
The background fact leading to filing of this petition is enumerated here below. The petitioner was appointed as workers employee on 31/8/1984 in the Department of Public Health Engineering, Government of Nagaland. Thereafter, order dated dated so and so. The petitioner was released from his service with effect from 30/9/2019 on completion of 35 years of service. While he was in service, he had filed one representation on.
So this is the main point. Before, he has filed a representation while he was in service, but you have not filed a representation, that is what he is saying.
My lord, I filed. I filed a single petition.
You have filed
Yes.
while you were in service,
Yes.
but only 4-5 days before your retirement. You have filed on 19th and you were retiring on 30th. But this petition was filed. He was supposed to retire in the year 2019 and his petition was filed in the year 2015.
My lord, before that, I was all along pursuing that I should be regularized, but the state respondent has not considered my case, so I have to submit a representation while I was.
So he has filed before retirement, just few days before retirement, he has filed a representation.
But the process is there.
And my lord, here in the writ appeal number 35 of 2022, those respondents in the writ appeal, here the petitioner and the respondents in the writ appeal were of similar situated person.
So
They
he
were,
was,
in fixed pay and retired in
Yes,
fixed
yes.
pay without any pensionary benefit. And the same, and in that writ appeal, this honorable court has dismissed the appeal.
by the government.
Yes, it was made by the state respondent.
So what you were saying, process. So this as per rule 2.
My lord, here rule 2 may not be relevant. However, my case is covered by the writ petition which I rely upon in the 96.
All right, all right.
2014 1010 and also.
So today I am short of time. I cannot pass an order today. I'll have to take this home and I can pass an order. Through video conferencing, I can pass. Today I'm short of time. No time for me. I'll have to go through this judgment and I'll have to go through the other court judgment.
And my lord, here in the writ appeal, the judgment of Daljit Singh, Prem Singh
Has been
well as
discussed,
all those
yes.
has been discussed in detail in this writ appeal. And
So then I'll conclude, I'll take it, I'll record, I'll pass an order later
Yes,
as CAV.
yes, ma'am.
All right. Hard Learner Council, Mr.
El Likasa Sangam, my lord.
L. Likasu, Sanctum.
Yes.
Likasal, and learned government advocate,
Yes.
Nagaland, Mr. Moa Imti. I'm correct, no? Reserve for judgment and order. Oh, you have given a copy of the rules. Yeah. Just a moment. Any record left with this?
No.
Yeah.
Hearing item number 36.
This your lordship. My lord, kindly allow 2 weeks time.
Yeah.
Oh, yes.
Because I also don't have any more time. If any submission will be made, I'll have to take the record to Assam and then I'll have to pronounce to, and then again I'll have to send the record to bus and train. Yes, this I'll take home. Along with the other one.
Hearing item number 38.
This one and the other one I'll take home. 36 also 2 weeks time, no? 2 weeks. Learned as agreed by both the parties, list the matter after 2 weeks. Yes, yes.
Lordship, for item number 38, that is later listed on 5th of March.
Learned counsel for the petitioner, Miss. Has prayed for 2 weeks time. List the matter after 2 weeks.
Hearing item number 40.
May I please, madam? This is a short matter. The issue is well covered by the judgment of this honorable court decided in 2016 for GLD 460 IR. I do testimony as simple judgment. 2016 for GLD 460 I have submitted the book this morning. I have a humble request, my lord. If the earlier also in this same case, the audios were turned off. The audios.
Okay,
of
okay.
YouTube, because this is
Relating to POSCO?
no, the case of diseases involved.
Okay, then it has to be turned off. It has to be turned off. P76 and POSCO, we have to turn off actually the. Yes.
Now, my lord, the next of the case, in the chief is there the petitioner and the respondent number 2. They were known to each other through Facebook and this social media. There were so many social media applications this. So after that, they met on 20th of January 2022 at Kohima in the public ground. There was a volleyball finals going on, which was organized by the Tribal Students Union. So they went to watch it, and then they were sitting in the ground. And then at that point of time, the respondent number 2, she was already engaged to be married to another person. So after about 1 or 2 months, and they had since they had a relationship.
So we have the